In Texas, parents of children with disabilities have a vital tool in their arsenal called the prior written notice. This written explanation serves a critical purpose. It must be provided by the school district anytime they propose or refuse changes related to a child's special education. It's important to understand that this notice is distinct from an ARD meeting invitation, which merely tells parents when to attend. Instead, the prior written notice lays out what decisions were made and the rationale behind them. And the circumstances under which schools must provide this notice are pivotal. It is essential anytime the district proposes or refuses changes concerning 4 core areas. First, identification, which involves determining whether your child qualifies as a student with a disability. Second, evaluation, which includes any testing for your child or the decision against such testing. Third, placement, regarding where and with whom your child will receive services. And fourth, the provision of free appropriate public education, which details the services and supports supposed to be outlined in your child's Individualized Education Program, or IEP. It's crucial to note that even refusals require a prior written notice. For instance, if you request a comprehensive evaluation and the district denies it, they are obligated to provide you with an explanation. Similarly, if an ARD committee declines to provide additional speech therapy or proposes changes in placement, those instances must also be documented in a prior written notice. The law mandates that parents receive clarity on these decisions. For a prior written notice to be compliant with legal standards, it must include 7 required elements. These are not mere formalities, they are essential for ensuring transparency and parental understanding. The first element must clearly outline the action being proposed or refused. The second should explain the rationale for that action. The third requires a summary of every evaluation, record, or report that informed the decision. Additionally, the notice should include a statement detailing your procedural safeguards along with instructions on how to obtain a copy of these rights. Fifth, it should provide resources for help if you need assistance in understanding your rights. The sixth element often gets overlooked. Districts must explain other options that were considered and why they were rejected. Lastly, any other relevant factors should be included. If any of these components are absent, it indicates an incomplete notice, and it's advisable to address this with the district in writing. Timing is another essential factor. The notice must reach parents at least 5 school days before the district implements any proposed changes, unless a shorter time frame is agreed upon. If any school staff member claims that sending information ahead of time, such as a notice, constitutes predetermination, you simply need to respond that you have the right to be prepared for the meeting, which does not constitute predetermination. This means that it is permissible to receive the notice prior to an ARD meeting, allowing parents to be informed ahead of time, or after a meeting to confirm what has been decided. Furthermore, the notice must be provided in the parent's native language or preferred mode of communication to ensure full understanding. However, there are common pitfalls to be vigilant about. Sometimes districts neglect to provide any notice at all, opting for verbal communication instead. Moreover, vague explanations such as "the committee determined it was not necessary" fail to deliver the necessary details and data. Missing elements, particularly the options that were considered, are also common red flags. Additionally, receiving a notice too late, after changes have already occurred, is unacceptable. Such issues should be documented and communicated to the district to ensure accountability. When you receive a prior written notice, it's advisable to read it immediately and compare its contents to the discussions held during the meeting. If there are discrepancies or missing elements, reach out to the case manager to address these specific issues directly. Understanding your options is crucial. You may agree to the terms, request another ARD meeting, seek mediation, file a state complaint, or even request a due process hearing. Keeping all notices is vital, because they collectively create a documentary record of your child's educational journey. As you approach these processes, keep 3 key ideas in mind. First, every decision, whether a yes or a no, should be backed by a written notice that includes substantive reasons. Second, be mindful of the 5-school-day timeline to prepare adequately for any changes. Lastly, always exercise your right to request information and clarifications in writing, as this process incurs no cost and reinforces your position as an informed advocate for your child. In conclusion, the prior written notice transforms informal verbal agreements into an official record with justifiable reasoning. Familiarizing yourself with the 4 critical triggers, the 7 required elements, and the 5-day notification rule empowers parents to effectively engage and hold the school district accountable for their child's education. For more information about the ARC of Harris County Special Education Advocacy Services, the Right to Learn, contact 713-957-1600, extension 116 or 118.